Welcome to SK Learn. Hello everybody. இன்று தினம் ஒரு சட்டம் பகுதியில் இன்று நாம் பார்க்க போவது procedural difference between section 200 and section 156(3) of CRPC. Section 200 of the Criminal Procedure Code 1973 states the procedure of the examination of the complainant and the witnesses. A magistrate taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present. If any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Provided that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses. If a public servant acting or purporting to act in the discharge of his official duties, or a court has made the complaint, or if the magistrate makes over the case for inquiry or trial to another magistrate under section 192. Provided further that if the magistrate makes over the case to another magistrate under section 192, after examining the complainant and the witnesses, the later magistrate need not re-examine them. The first half of the section empowers the magistrate to record the testimonies of the complainant and the witnesses present. The second half of the section discusses the cases where the magistrate is absolved of his responsibility. Section 156 of the Criminal Procedure Code 1973 states that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 30. Would have power to know proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under the section to investigate. Any magistrate empowered under section 190 may order such an investigation as mentioned above. Section 190 of CRPC discusses about the cognizance of offences by magistrate. When the complaint is presented before a magistrate, the magistrate has three ways to proceed. First one, take cognizance of the complaint and proceed with the examination of section 200 CRPC. Second, direct an investigation under section 156(3) of CRPC. Third, refuse to take the cognizance and drop the case. When proceeded with the first option, the examination of the complaint was to be undertaken to be able to form an opinion whether there are sufficient grounds to proceed or not. If there are no sufficient grounds to proceed, then in the case the court shall dismiss the complaint. When proceeded with the second option, the order of an investigation has to be given by the magistrate before the cognizance has been taken on complaint. Therefore, if the magistrate has moved forward using section 200 CRPC, that's taking cognizance, the magistrate cannot trace back to section 156(3) of CRPC and cannot order an investigation available under this section. Please subscribe, and if you like it, and share it. It may be useful to you and others.